The Judiciary. Learning objectives. The merit plan is not used in Texas. That's to make judicial selections less political. Civil and criminal cases. Civil cases concern private rights and remedies and usually involve private parties or organizations, although the government may on occasion be a party to a civil case. This is important. The burden of proof in civil cases is usually preponderance of the evidence, which means whichever party has more evidence or proof on its side should win the case, no matter how slight the advantage is. If they have 51% of the proof, they win. Another civil burden of proof is clear and convincing evidence, and that's used in cases like termination of parental rights. Criminal cases involve a violation of the penal law that is prosecuted by the state. The burden of proof is the duty of a party to prove its position in court, and the burden of proof in a criminal case is beyond a reasonable doubt. The standard used to determine the guilt or innocence of a person criminally charged to prove a defendant guilty. The state must provide sufficient evidence of guilt so that jurors have no doubt that might cause a reasonable person to question whether the accused was guilty. Original jurisdiction is the power to try a case being heard for the first time. This is important. Appellate jurisdiction, the power vested in an appellate court to review and revise the judicial action of an inferior court. Briefs. Written arguments prepared by lawyers arguing a case in court that summarize the facts of the case, the pertinent laws, and the application of those laws to the facts supporting their positions. Double jeopardy, a second prosecution for the same offense after an acquittal in the first trial. Double jeopardy applies in criminal cases. City ordinances. Municipal courts, like traffic tickets. De novo trials are trials in which a higher court completely retries the case, in contrast to an appeal where a higher court simply reviews the law as decided by a lower court. Justices of the peace. They have jurisdiction over criminal cases where the fine is less than $500 and civil cases where the dispute involves less than $10,000. They can issue warrants for search and arrest. They handle landlord-tenant cases, and that's the most frequent civil case that's filed in Texas courts. Court structure. This chart is extremely important. I recommend that you print it out and learn as much as you can about this. There will be extensive questions on this slide. This shows you how the courts are set up. You have the two highest courts. You have your 14 courts of appeals. You have your district courts, which are the main trial courts in Texas, your county level courts, your justice of the peace courts, and your municipal courts. And this shows you the qualifications of the courts for those different positions. County courts. Each of the 254 Texas counties has a county court. The county judge is elected for a 4-year term, and they can also handle probate matters. The minimum qualifications to become a judge and the method by which the judges are selected are different for the different courts. Justice of the peace courts are authorized by the Texas Constitution. They do not have to be a licensed attorney. They just take an 80-hour course plus a 20-hour course each year. County courts. Each of the 254 counties in Texas has a county court presided over by the county judge, sometimes called the Constitutional County Court. The Constitution does not require that a county judge possess a law degree. Salaries are paid by the county and they vary greatly. County courts handle probate and other civil matters in which the dispute is between $200 and $10,000. Their criminal jurisdiction is confined to serious misdemeanors for which punishment is a fine greater than $500 or a jail sentence not to exceed 1 year. Because the constitutional county judge also has an administrative responsibility as the presiding officer of the Commissioner's Court, and that's the governing body for Texas counties and not a judicial entity at all, he or she may have little time to handle judicial matters. County courts at law. In certain counties, to act as an auxiliary or supplemental court. In some, but not all Texas counties, we have county courts at law. The qualification of the judges in these statutory courts at law vary according to the statute that established each particular court. In addition to presiding in the county, a court at law judge must have 4 years' experience as a practicing attorney or a judge. There are 365 district courts, all of which function as single judge courts. They're elected for 4-year terms by the voters in their district, and they must be at least 25 years of age, a resident of the district for 2 years, a citizen of the United States, and a licensed practicing lawyer or judge for a combined 4 years. So here's a chart that sets out civil and criminal cases filed in Texas courts. As you can see, the Supreme Court handles 100% civil cases, and the Court of Criminal Appeals handles 100% criminal. It's divided almost equally in the courts of appeals. District courts handle more civil cases. This is where you would file for divorce. And municipal courts handle more criminal cases because of traffic tickets. Felony cases are those which comprise about 1/3 of the criminal caseload. That's in district court. Drug offenses account for about 30% of the criminal cases that are filed in Texas district courts. District courts, this is important, are the chief trial courts in the state. They have jurisdiction over felony cases, civil cases that exceed more than 200, juvenile cases, and heavy caseloads result in plea bargaining. Courts of appeals. We have 14 courts of appeals. They hear appeals for civil and criminal cases. Only a very small percentage of cases are appealed. Court of Criminal Appeals. Dual system of courts of last resort. Our two highest courts in Texas, this is very important, are the Texas Supreme Court and the Texas Court of Criminal Appeals. The Texas Court of Criminal Appeals has exclusive jurisdiction over automatic appeals and death penalty cases. That means it is the only court that hears those cases. In 2015, the courts of appeals disposed of over 11,000 cases, and they reversed the decision of the trial court in only 7% of those cases. The Supreme Court is the final court of appeals in civil and juvenile cases, and they have original jurisdiction over the issuance of writs or the conduct of proceedings for involuntary retirement or removal of judges. They have the power to establish rules for administration of justice. Original jurisdiction means that's the first court to hear that type of case. Supreme Court. 1 Chief Justice and 8 Associate Justices. They're elected for 6-year terms. They have a policy-making role, like in the case of Edgewood versus Kirby. That FPO across this photograph means for placement only, so I guess that didn't get taken out of this slide when they gave it to us. Texas has a dual system of courts of last resort. The Texas Supreme Court is the highest state appellate court in civil matters, and the Texas Court of Criminal Appeals is the highest state appellate court in criminal matters. Among the other 49 states, only Oklahoma has a similar bifurcated system. In 1989, the Texas Supreme Court unanimously declared in Edgewood versus Kirby that the wide disparities between the rich and the poor school districts were unacceptable. And that is an example of the types of cases that they hear. And that's Nathan Hecht sitting in the center in the front. He's the Chief Justice of that court. Grand juries determine if there's sufficient evidence to bring an accused to trial. They consist of 12 people, and an information is, an indictment is a formal written accusation by a grand jury against a person charged with a crime when it's been determined that there's sufficient evidence to bring the person to trial. The grand jury will say, we have a true bill if they think the person should be indicted, and they say it's a no bill if they think there's not enough evidence for the person to be indicted. An information is a written accusation made by the prosecutor against the party charged with a minor crime. It's an alternative to an indictment and does not involve the grand jury. The prosecutor just simply fills out that document themselves. It looks just like an indictment, except it doesn't have a signature of a grand jury foreperson. Petit trial jury, that's a jury for a criminal or civil trial. County courts have 6-person juries. District courts have 12-person juries. That's important. Selection of a jury panel. Challenge for cause. A petit jury is a jury for a civil or a criminal trial to be distinguished from a grand jury. During voir dire, that's the beginning of the trial, that portion of the trial where the attorneys select jurors for a case. A challenge for cause is a request to a judge that a certain prospective juror not be allowed to serve on the jury for a specific reason, such as bias or knowledge of the case. For example, if someone said they always believe police officers, then either attorney could challenge that person for cause and have the person excluded from serving on that jury. Peremptory challenge is a challenge made by a prospective juror without being required to give a reason for removal, and the number of such challenges allotted to the prosecution and defense is limited. So that can be for any reason. A hung jury is a jury that is unable to agree on a verdict after a suitable period of deliberation. The result is a mistrial. And the venire is the jury panel. They're randomly selected from among those individuals who are registered to vote that have a Texas driver's license or have a Texas identification card, and other systems that are used to select possible jurors. To be qualified to vote, you have to be at least 18 years of age. To serve on a jury, you have to be 18 years of age, qualified to vote, not indicted for a felony or theft, and people can exempt themselves from voting if they are over 70 years of age, high school or college students, primary caretakers for an invalid, or a person with legal custody of a child younger than 12, and their service would leave the child without adequate supervision. The merit plan is to avoid partisan politics. Texas judges are almost all elected. There are a few city judges that are selected or hired by the city council. Otherwise, judges are elected. State by state selection of Supreme Court justices. On this chart, you can see Texas is one of the states that uses partisan elections to appoint their judges, as opposed to the other systems that we have, nonpartisan, appointed, or appointed by the governor or the legislature. And this comes from your Council of Governments. The Council of Governments is a an entity that is used to assist local governments in research and resources. The politics of judicial selection in Texas, voter knowledge, partisanship, and campaign contributions. Both systematic research and abundant anecdotal evidence indicate that most voters in Texas are unaware of the candidate's qualifications or experience. Because they know so little about the individual candidates in general elections, they rely heavily on the candidate's partisan affiliation as a cue to determine how to vote. Because voters often look for simple voting cues such as familiarity with the candidate's name or party identification, candidates often want to spend as much money as possible to make their name or candidacy well known. Judges seek publicity through social media. Ethnic, racial, and gender diversity. There's limited ethnic, racial diversity. Gender diversity varies across court levels. Women are found on a majority of the courts of appeals, but they are only present in getting close to 50% on the Court of Criminal Appeals in Texas. The lower courts are more male-dominated. Ethnicity, race, and gender of Texas judges. As you can see, women and Hispanics are greatly underrepresented in our judiciary in Texas.